No.
Yes.
Welcome to the Washington State Gambling Commission hybrid meeting. Today it's being held on October 6th and 7th. We are in person at the Washington State Liquor and Cannabis Board at 9:34 a.m. Today's meeting will be recorded and live streaming through TVW. Because we are holding this meeting telephonically as well as in person, I'm going to ask Director Griffin to call the roll of the commission members to ensure a quorum.
Good morning, Chair, Commissioners, ex officios, Vice Chair Patterson. Are you able to unmute, go on camera? Okay, Commissioner Sizemore.
Here.
Commissioner Reeves. Here. Commissioner Lawson.
Here.
Make sure you're on mute.
Chair Levy.
I'm here.
And Vice Chair Patterson. I see you.
I'm here, yeah.
Thank you. Then Senator Conway was not going to be able to join us until about 10:30.
Okay.
Senator Holy.
He texted me, he's gonna be a little bit late.
And I see Representative Klova.
Hello.
Good morning. And Representative Vick. So all 5 commissioners are here. Chair.
Great, thank you. During the meeting, we will accept public comments. If you would like to submit a public comment via email, please submit them to askus@wsgc.wa.gov. If you have any questions regarding the meeting, please contact Julie Anderson at julie.anderson@wsgc.wa.gov. The telephone lines are currently muted. When I ask for public comment, please unmute your line, provide your comment, and then remute your phone. Please do not interrupt individuals who are speaking. Each person will have the opportunity to comment. When you provide comment, please clearly state your name, your contact information if you'd like to receive a summary of all comments, and who you are representing. Okay, so now we are going to move to the consent agenda. So we have the September 8th commission meeting minutes, new licenses and class 3 employees, electronic raffle and manufacturing reports, sports wagering vendor reports, house bank card room report, and the 2023 commission meeting schedule. One thing to note there is that the January meeting is occurring 1 week earlier than normal. So it's not going to be the second week, it'll be the first week of the month. We are still determining locations, so we'll vote on those at a later time. Does anybody have any comment? Commissioners or ex officios? Any public comment from anyone? Julie?
No, ma'am.
Okay. Do we have a motion?
I would make a motion to move the consent agenda as presented by staff.
Okay. We have a motion by Commissioner Sizemore. Do we have a second?
Second.
Second by Commissioner Reeves. Is there any further discussion? Okay, all those in favor say aye.
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 Okay, the motion passes 5-0. 1 second here. So next, we have a petition for review of an initial order in the matter of the Pub Tavern, docket number 06. Oh wait, we have the director's report. Sorry.
Fine.
Getting ahead of the game. Go for it.
So I just have information to pass along about the Centennial Accord, which is in your packet. Apologies because it doesn't have any titles to it, But the Centennial Accord provides framework for government-to-government relations with sovereign governments. And that meeting, the Centennial Accord, will actually occur on October 25th at Tulalip. In your packet, you will find a summary of the work that we've completed during the last fiscal year. And it's quite an impressive list and that staff were able to complete in partnership with the tribes during this period of time, given that staff was short. We had staffing issues during that time, and we know that the tribes were short-staffed as well. So yes, I encourage everyone to take a look at the list. We had 3 amendments to compacts and mutually agreed to amend 5 compacts with sports wagers to allow sports wagering. 8 tribes opened sports wagering operations. Our electronic gambling lab started publishing a monthly report to enhance communication with our tribal partners. And we sent 8 information bulletins on suspicious activities and crimes occurring that may impact the tribes. And we mutually agreed to annual certification fees, or excuse me, annual class 3 certifications fees that would just involve 1 payment with 2 tribes. We agreed to 29 compact clarifications or MOUs, 317. We concurred with 317 IC and game rule changes, and we held our first new agent training since the pandemic. And so first time in 2 years, we had 40 participants representing 15 tribes, and some of the information that's shared with the, when we say new agent training, that's new tribal gaming agent training. And some of the topics include tribal gaming history, licensing regulation of class 3 gaming. And so that is just a few of the high points. So that is all I have for you. Thank you.
Thank you very much, Director Griffin. Sorry to accidentally overlook you.
It's all good.
All right, so now next we have a petition for review of an initial order in the matter of the Pub Tavern, docket number 06-2021-GMB-00182. The petitioner is represented by Mr. George Telquist and Ms. Andrea Clare. Gambling Commission staff is represented by AAG Doug Vandenbrink. The parties will be permitted 10 minutes of argument each, and after hearing oral argument, commissioners may ask questions of the parties, and then the commission will go into closed session to deliberate. As the petitioner, the Pub Tavern will present oral argument first, and you may also reserve a portion of your 10 minutes for rebuttal if you would like. So do we have everybody present?
Madam Chair, this is Commissioner Patterson. Madam Chair,
Yes?
I'm unable to see you or the room. I don't know if other commissioners who are participating virtually are having the same problem, or if it's my problem here at home. I'd like to be able to see you and the room if possible.
Does she
Okay.
have it on gallery view? Why is that not showing up there?
Can you see
I
anybody?
know.
Can you see anybody? Or is,
Well, no one's on camera. I mean, it says Julie Anderson, but I don't see anyone on camera. It says Sarah Lawson. Sarah must not be on camera. I can see myself.
So Julie, does she have it on gallery view or does she have it on?
Okay, now I can see Sarah. Sarah, can you see them? Are you able
I
to
can see them, yeah.
Okay.
I don't have a problem.
Okay, I apologize. It must be something that I'm not doing right here. I'm on my end. Go ahead. I don't want to interrupt the meeting. I just thought if you could fix it, so be it. Otherwise, it's my problem.
okay. Sorry, Commissioner Patterson. Yeah, I'm not sure how to fix that.
No
So
problem.
we'll get back to the oral argument. Is the Pub Tavern here?
Or something.
Yes. Andrea Claire.
And I see the AAG, I believe, Doug Vanderbrake here. So we'll go ahead and start with the Pub Tavern. You'll have 10 minutes total, so you can save some for rebuttal or use that all now.
Yeah, can I save some for rebuttal, or is that on my own to keep track?
What was that?
Can I save a minute for rebuttal or 2 minutes for rebuttal, or do I need to keep track of that and just stop on my own when I hit that mark?
We'll set a stopwatch.
Okay,
So you want 1 or 2 minutes? So
2, please.
2 minutes. Okay, so at 8 minutes, I will stop you if you're still talking.
Thank you.
All right, go ahead.
Okay, thank you so much for the opportunity to present this petition before you. In terms of where I hope to go, my roadmap, so to speak, in terms of why this order is inaccurate, and I ask you to consider, number one, that the evidence does not support the charges that were provided in the notice of charges to the Pub Tavern. Number 2, the conduct and actions of the Pub Tavern, specifically as it relates to the sole owner presently, Mark Howder, doesn't justify revocation of the commercial stimulus license approval that was obtained in 2014. And then number 3, I want to let you know that when the application was submitted in 2014, there was no attempt to conceal, misrepresent, or mislead the commission in any way, shape, or form. And I think that it's important to note that that has to be viewed when the application was submitted. To the extent there are changes, that was not addressed in the administrative charges. So in the administrative charges against the Pub Tavern, the commission alleges that the Pub Tavern, in its application, again for a license in 2014, provided the commission with false or misleading statements by omitting Tim Howder, the brother of Mark Howder, from its application or disclosure. And secondly, by listing funds that came from a corporation that Mark was not an owner. And then also in the administrative charges, it suggests Tim is a substantial interest holder in the Pub Tavern. I'd like to deal with that separately. But as to those 2 bases, that the application was submitted with false or misleading statements and that the funds did not come from a corporation that Mark was an owner of, I want to point out that when this application was approved, it did go through special agent for additional vetting, and everything had checked out. Everything was provided. The owners at that time were compliant. There didn't appear to be any issues for purposes of approving the application. So fast forward in 2019, when the investigation started and the commission decided to file charges, it suggested that these funds were not appropriately sourced. If you look at the initial order, finding 466 says that at the time the Pub Tavern sought its gambling license, Tim, the brother of Mark, and his father Sala were the owners and members of Altopia Properties, where the funds came from. And this is wrong. If you look at the exhibit that was submitted by the state, it shows in April 2014, the Secretary of State website for the Altopia Properties renewal shows that Tim Howder was a manager. And I think that the ALJ was somewhat confused as the testimony went on, but a manager is not necessarily an owner. A member is an owner when it comes to businesses and corporations. There are 2 types, as the CPA testified. There's a member managed LLC, where the owners are the managers of the business, and then there's a manager managed LLC, where they hire a third-party manager for the business. For Altopia Properties, where these funds came from that Mark had used, Tim was the manager. The exhibit shows that Tim was the manager of this manager managed LLC. Tim was also the registered agent. So I could see the confusion, but it doesn't support the conclusion that Tim was an owner of Altopia Properties. On the same exhibit, it shows Mark and his father were both members, and it clearly identifies Tim as a manager. Additionally, And of course, the commission could have requested anything from the licensee or applicant, but tax returns were supplied at the hearing. Exhibit 20 and 21 showed that in 2013, for Altopia Properties, where these funds came from, Mark was a 45% owner and Sala was a 55% owner. Exhibit 21 shows in 2014, again, looking at the K1s for the business, it was the same split. Mark held 45%, Sala held 55%. Those were the two members, owners of Altopia Properties. Essentially, in 2014, Mark used funds that he had as an owner in one company, Altopia Properties, for his purchase in Clearwater Investment, which is the Pub Tavern. Nothing inappropriate there, but the ALJ got it wrong. And the evidence, the documented evidence is there to support that. There were some changes to Altopia Properties later. Altopia Properties had no affiliation or relationship with Clearwater at all. But I think, again, the ALJ was confused with these changes that occurred later. But if you go back to the 2014, when those funds were used, they were, it was from a company that was owned by Mark Howder, and that was established. There was also the suggestion or allegation in the charges that there was an omission of Tim Howder from the application. The state bases its opinion that he should have been included in the application because he was a substantial interest holder. And I'll get to that law later, but they suggest that because Tim Howder negotiated the purchase price of the Pub Tavern, and there was no evidence that Tim negotiated at all. Exhibit 11 that was admitted into the hearing were meeting minutes. It showed Tim was there as a power of attorney on behalf of his brother, and it sets forth the ownership interest in Clearwater Investments. Those were the owners that were on the application and that were disclosed. It was Abernathy, who was going to be an owner and a manager, Brett Heinen, and then Mark Howder. Tim signed on behalf of his brother as POA because he was a proxy for his brother who resides in Tennessee, but he's always been the owner of Clearwater Investments. There were some changes in terms of the ownership structure, but in 2014, that was how it was supposed to be, and that was accurate when they submitted the application. The state also suggests that perhaps the making of the earnest money down payment to the former owner was a problem, or suggested that Tim was a substantial interest holder. Once again, Tim was the manager of Altopia Properties where Mark used his funds. Tim was able to sign the check, but there's no evidence that the money was Tim's. The evidence was that the money was Mark's, and Mark directed him to put his ownership interest funds that he's entitled to from one company to purchase the other one. And the CPA testified at the hearing that that was the case. There were another basis was that he signed checks on behalf of the business. The only evidence of that was that there was 3 deposits that had Tim's name on it in a ledger. The bookkeeper for Clearwater Property or Clearwater Investments testified that the checks would come in and she put them in a chart of accounts. If you're familiar with QuickBooks or bookkeeping at all, the chart of accounts was to the shareholders. So it was income. It was a deposit that was made. It was submitted by Tim. That's not a problem. He's POA. But the evidence was that was Mark's money.
8 minutes, just.
Okay. All right. Let me just wrap up very briefly. That the other basis was that that Tim would take down the games. And if you look at the entire record, there was 0 evidence that Tim was ever involved in taking down the games. And that was a critical point. But I'm going to go ahead and reserve the rest of my arguments and comments for rebuttal.
Okay, perfect. So you have about 1.5 minutes left on your rebuttal.
Thank you.
Okay, is AAG Doug Vanderbrake?
Thank you, Commissioners. My name is Doug Vanderbrake. I'm an Assistant Attorney General representing Gambling Commission staff in this review hearing today. A note at the outset, some of the names I'm going to reference. There's a Tim Howder, and Mark Howder. I'm going to refer to them by their first names. No disrespect is intended. and it would be consistent with how they've been referred to throughout the record. Now, this case is not solely about who's an owner. It's also about who's a substantial interest holder. Now, the commission's regulation that defines a substantial interest holder states in relevant part, a substantial interest holder means one, a person who has actual or potential influence over the management or operation of any organization, association, or other business entity. And second, evidence of substantial interest may include, but is not limited to, directly or indirectly owning, operating, managing, or controlling an entity or any part of an entity. Now here, the administrative law judge heard testimony from 9 witnesses and considered 31 exhibits. And based on that information, found and concluded that Tim Howder was intimately involved in this business, and that it was undisputed that for over at least a 4-year period, Tim Howder was involved in managing the operations of the pub tavern. Now, the administrative law judge also considered the testimony from the special agent who conducted the investigation, and found that Tim Howder was involved in going to the business and conducting what I'll refer to as the dailies. That means looking at the pull tab games, the winners and the losers, handling the cash related to the pay in and payout. Okay, he wrote, so his involvement was not just, as, merely as a manager, as a proxy for his brother, Mark. All right. Now, I think it's important to state at the outset, the real gist of the pub tavern's argument is that Tim Howder cannot be considered a substantial interest holder because he is purportedly acting under the power of attorney by his brother Mark. And I say purportedly because this purported power of attorney is not on the record. But it doesn't matter, even if it was, because Tim Howder's involvement in the business has been so substantial, it's clear that he has actual or potential influence over the management or operation of the business, and he directly or indirectly manages or operates the business. Now, when the agent made a spot inspection of the business, he talked to the bartender and about the business license. The bartender didn't know the answer and said she would contact the owner, Tim. All right. She comes back and says, okay, the business license is here. Ask the agent to put the business license in the office. The agent goes in there and sees an employee contact list. On that list, the first 2 names is owners, Tim Howder. That prompted this investigation because the agent didn't recognize the name Tim Howder as an owner. In the course of the investigation, the agent made contemporaneous notes of his interviews of people he talked to during the investigation. And 2 people indicated to that agent, as the agent testified, that Tim Howder had mentioned that there was something in his background that would prevent him from getting a gambling or liquor license. And the agent talked with Tim Howder and testified about that conversation and his notes of that conversation. But Tim Howder had mentioned that he had a criminal history, right? So now that's not a basis of the charges, but it goes to the motive as to why he was not disclosed his interest, all right, in this business. So he's there at the business, managing it, directly handling activities directly related to gambling, such as the pull tabs, looking at the flares, the dead games, handling the cash related to that. When an employee at the business has a question, who did they call? Tim, the owner. All right. Now, the other thing here is if Tim Howder is acting solely as power of attorney for his brother, it shows, right? It shows that he's a substantial interest holder. And to conclude that a person can have this level of scope and extent of involvement in an organizational gambling licensee through the artifice or the instrument of a power of attorney document would basically render meaningless the requirement that anyone that has influence, actual, potential, direct or indirect, over that gambling business does not need to be disclosed to the commission. And that's not the case. A general manager for an organizational licensee needs to be disclosed. They need to apply, they need to be vetted, they need to be fingerprinted, there needs to be the criminal history background check. All right, here, Tim Howder is basically the general manager, okay? But he has never disclosed, at no time did they ever disclose Tim Howder's involvement. The ALJ correctly picked up on this. At the very least, the pub tavern should have disclosed to the commission that one of its owners was acting through a power of attorney, and this is who the power of attorney was. The commission, to keep in mind, the administrative law judge, it's a pub tavern argued in its petition for review. Much of the evidence in the record is hearsay. The pub tavern objected to admission of that, much of that information during the hearing. The administrative law judge noted the objection, overruled it, and said that he would put more weight on the live testimony as opposed to the documents. So there is hearsay in this record, yes. All right, but hearsay is admissible in these APA proceedings. The administrative law judge noted that on the record and stated about what weight he would give to this. So Tim Howder, as the ALJ recognized, is intimately involved in this business. He was never disclosed to the commission. He should have been. Now, was he an owner? You know, in form, no. In substance, yes. He was a hidden owner. A final note about the administrative charges. Okay, they're basically the first basis for the charge is a false or misleading information, right, for failure to entirely omit Tim Howder from the application, and also reporting that Mark Howder reported that his source of funds came from a corporation of which he was not an owner. That second piece, commission staff, based on evidence presented at the hearing, abandoned that part of the argument, that part of the allegation, because evidence presented during the hearing established that Mark Howder, in fact, was an owner, all right, of the business, of the corporation of which reported a source of funds came from. All right, so the ALJ's order doesn't find that Mark Howder was not an owner of that corporation. Staff abandoned that argument. However, we still submit a preponderance of the evidence established that Tim Howder is clearly a substantial interest holder in the licensee. He was also an owner. He was never disclosed anywhere at any time. For all those reasons and the reasons in the ALJ's conclusions of law, we respectfully request the commission affirm the initial order in its entirety and issue a final order finding that the pub tavern's license, its punch board pull tab license, should be revoked. That concludes my argument, unless there are any questions. Thank you.
Thank you, AAG. Doug Vanderbrake, we will go ahead and allow for Ms. Claire to have her additional 1:30 for rebuttal.
Thank you. I want to remind the commission that its mission is to ensure that gambling is legal and honest. Nothing occurred here that would thwart that mission. In this substantial interest holder, it talks about a person who has actual interest, potential influence, like criminal activity or organized crime influence over an operation. There was zero evidence here that Tim Howder handled cash, that he was even that he was seen doing the dailies or any type of management work. He's done no management. In 2014, Abernathy was supposed to be the manager. Something happened and he had to go and was bought out by the other two. And then we had various managers, but there's no evidence of anyone saying he was managing. No, he never had his hands on the money that related to the gambling activities. The evidence was he assisted from time to time. Mark Howder didn't need to disclose him because he wasn't a substantial interest holder. And a reasonable person should be able to look at the WAC and understand if they need to do that. There's no allegation in the charges that you have to disclose a POA. That wasn't a basis. This is just pure speculation that they believe he was involved. They call it intimately involved. But if you look at the record, even the findings that the ALJ got wrong don't support that he was intimately involved making decisions and handling gambling activities or being paid based on gambling receipts as per the WAC.
That's your time.
Thank you.
Thank you. All right, do any commissioners have any questions for either AAG Vanderbrink or Dr. Vanderbrink or Ms. Claire? Lots of questions. Commissioner Patterson, do you have any questions or anyone? Mr. Lawson? Okay, then at this time of 10:04 a.m., the Gambling Commission will be going into closed session to discuss the petition for review with legal counsel. So we will be back shortly.
Morning, Suzanne.
Still live.
Yeah, I can still say good morning. I
Mike
think
is
that's
still
in the
on.
rules.
I think it